All right, good afternoon, everyone. My name is Bennett Jensen. I'm the Director of Legal at Egale Canada, and I'm going to be moderating today's session. Thank you so much for joining us. We are going to start by acknowledging with gratitude the land that we're presenting from today across Turtle Island, known as Canada. And today's session is being put on by Egale along with three other nonprofit organizations and a private law firm. So the Canada US Border Rights Clinic, Rainbow Railroad, and the 519, as well as Green and Spiegel. You'll be meeting our four panelists or four additional speakers today. So I'll let them introduce themselves when they begin to speak, but I'm thrilled to have such expertise with us today. So just to set the stage as to why we're having this conversation today, all of the panelists, as well as the organizations we represent, are well aware of how difficult the circumstances are for 2S LGBTQI plus folks in the United States right now. And our organizations have been really inundated with requests from Americans seeking to come to Canada and wanting to understand what options exist. For the nonprofits that are participating in today's call, we unfortunately don't have the capacity to offer individual legal assistance to US citizens at this time, but we decided to come together to create this webinar to hopefully provide guidance about the major pathways that exist that may be worth exploring. So there are some factors, all sorts of factors, actually, risk areas that need to be considered that we'll cover today. And we are grateful for all of the questions that we have received from attendees. One point of clarification is that our focus, as I've said, is to explore the main immigration pathways. It won't be an exhaustive discussion, but we do hope to touch on the major categories that are worth exploring. We won't be able to speak to some of what we're calling settlement questions, so things like accessing school or healthcare within Canada. Those are beyond the scope of our session today. We encourage you, though, throughout the session to use the Q&A function, and we'll address as many questions as we can. For the questions that we received in advance, we've tried to incorporate them into the remarks that we're sharing today. This session is really focused on US citizens, and those are US citizens by naturalization or by birth. There's no distinction relevant to the topics we're discussing today. For non-US citizens, there are other considerations, risks, factors to consider, namely, or the most important one being the Safe Third Country Agreement and its possible implications for non-US citizens seeking to come into Canada from the US. So for non-US citizens, we encourage you to go to Canada Border Clinic .org, excuse me, for more information and resources to make sure that you're well supported. The final caveat that I'll say is, as we all know, the immigration realities are changing constantly. We're having this conversation on May 6th, 2025. So the information we're providing is valid as of today, but may shift. And the content we're also discussing is just that information and not legal advice. In terms of today's agenda, we've already gotten started by setting the stage. My colleagues will take you through some specific immigration pathways, and we'll then end with some additional resources and questions that we may not have covered. The final thing I'll say by way of setting the stage is just to offer some sober comments about the realities that we're facing in Canada. So sometimes I think that Canada is given, people imagine Canada to be sort of a perfect utopia. And unfortunately, that's not the case. Trans folks and queer folks in general have been increasingly under attack in recent years, both in the social context, but also through policy and legislation. So we have one province right now where there's been legislation passed to restrict access to gender affirming care for young people. It's currently before the courts, but just like with all the immigration information we're talking about, the situation for trans folks in the country is fluctuated. And we're also in a moment where there is increasing political focus on securing the border, and this has implications for immigration pathways as well. With that, I'm going to turn it to my colleague Jen for some language comments.
Thanks so much, Bennett. Yeah, so my name is Jen McIntyre. I'm the clinic coordinator at the Canada-US Border Rights Clinic. Some of the terminology that we use in Canada is different than the terminology used in the United States. So we have here on the slide some examples of that terminology. Refugee claimant is the legal term to identify the immigration status of someone who is asking Canada for protection. The equivalent term that is used in the US is asylum seeker. Similarly, someone whose protection claim has been accepted by Canada will be granted status as either a protected person or a convention refugee, with the equivalent term in the US being asylee. Knowing Canadian terminology here will help you understand information that you read on the Government of Canada websites, as well as in other resources that we're going to share with you today. However, that said, even though we're all based in Canada, today's presentation will use the term asylum rather than refugee claimant or refugee to avoid any confusion, knowing that much of the audience is based in the US. And then there are two acronyms for Canadian government departments that will be used throughout the webinar that you should take note of. The first is IRCC, which is the acronym for Immigration, Refugees, Citizenship Canada. As is clear from the name, this is the federal department responsible for matters related to immigration, refugee protection, and citizenship. IRCC's mandate is similar to that of U.S. Citizenship and Immigration Services, or USCIS, as it's called. And then the second acronym is CBSA, which stands for the Canada Border Services Agency. The CBSA is an enforcement agency responsible for border patrol, or border control, I should say. This includes carrying out removals from Canada. CBSA's mandate is sort of like a combination of two US agencies, US Customs and Border Protection, or CBP, and Immigration and Customs Enforcement, or ICE. You can move to the next slide. US citizens regularly enter Canada and do not require tourist visas to visit for up to 180 days. CBSA will require proof of US citizenship at the border, which they list as a passport, a birth certificate, a certificate of citizenship or naturalization, or a certificate of Indian status with your photo. It's important to know that visitors to Canada are not allowed to work here. Minor children of visitors are allowed to go to school if they get a study permit and will have to pay school fees that vary depending on the province where they live. Some people choose to enter Canada as a visitor first and then later apply for a work permit or another immigration category once they're in the country. And those immigration categories will be covered later on in this presentation. Even though US citizens do not need tourist visas, it's important to know that CBSA officers do have a lot of discretion at the border, including discretion, I should say at the border or an airport, including discretion to admit someone for less than 180 days or to simply refuse them entry to Canada. The reason for refusal could be one of many. It might be because the person has a criminal record, or because CBSA is concerned that the person will not return to the US within 180 days. For example, it might raise suspicions if someone comes to the border with a packed U-Haul full of belongings. Just something for you to think about. We've received quite a few questions about traveling to Canada with pets. This information is very situation specific and it's outside of our area of expertise. But we will provide a link to a Government of Canada website with information about traveling to Canada with pets. Many US citizens that I talk to ask me about the Safe Third Country Agreement. This is an agreement between Canada and the US that determines which country will consider an asylum claim. It is typically whichever of the two countries a person is in first, with some exceptions. However, the Safe Third Country Agreement does not apply to US citizens. If you are a US citizen, you are not required to meet an exception. That said, if there's anybody watching this webinar today who is not a US citizen, as Bennett mentioned, then it's very important that you learn about the Safe Third Country Agreement, and you can do so by visiting the website for the Canada-US Border Rights Clinic. And finally, in response to some concerns that we've received prior to the webinar about the possibility of harassment or poor treatment at the border, CBSA officers are bound in the behavior by a code of conduct. If you are concerned about your treatment by an officer, you have the right to submit a complaint to the agency through their website. Remember, though, that CBSA is an enforcement agency and their job is not to extend a friendly Canadian welcome at the border, but to police the movement of trade and people. So with that, I'll turn it back to Bennett.
Thanks, Jen. We'll now turn to the first category of immigration we'll be talking about, which is asylum claims. And my colleague Swati will be taking us through this.
Great. Good afternoon, everybody, or morning or evening, depending on your time zone. My name is Swati. I'm the Director of Protection Initiatives at Rainbow Railroad. I'm also an immigration and refugee lawyer, and I've done a lot of work supporting LGBTQ communities. So asylum claims, yes, a common question that we're seeing increasingly from US citizens is whether they might potentially be able to claim asylum in Canada in light of the worsening situation for LGBTQ rights in the US. And in assessing whether an asylum claim is a viable option for you, I think it's really helpful to first understand what an asylum claim is, what it isn't, and what are the requirements that you have to meet. So at a very base level, if you are claiming asylum, you are stating that you are being persecuted in your country of citizenship, and you can no longer live safely anywhere in that country. Therefore, you are asking for another country to offer you that protection, and in this case, you'd be asking for Canada to offer you protection or asylum. So that's a pretty straightforward definition in general, and as my colleague Jen just mentioned, US citizens can enter Canada and claim asylum if they want. They can exercise that right. They're not subject to the Safe Third Country Agreement. They can make a claim at the border or the port of entry, or they can come into Canada and then later make an inland claim. But it is a very high burden to qualify as an asylee under the law. And Bennett, if you can just go to the next slide. Yeah, great, thanks. It's a very high burden. The legal definition of an asylee is really restrictive, and it applies only to a very specific category of people. So what is that category of people? Let's break down the components of the definition. So in order to qualify as an asylee, you must first establish that you have a well-founded fear of persecution based on one or more of the grounds that you see here on the slide. So that would be race, religion, nationality, membership in a particular social group, or your political opinion. And if you are fleeing persecution based on your sexual orientation or gender identity and expression, that falls under particular social group. And a couple things to note here about this, what constitutes persecution under the law. It is actually a very high bar and quite a substantive threshold. And persecution usually involves really serious human rights violations, often systematic or systemic in nature. And so there may be things that are happening that feel persecutory, but don't actually meet this legal definition of persecution. For example, someone who's facing really serious and protracted employment discrimination based on their gender identity or their expression or presentation, and let's say they can't get a job, they can't meet their basic needs, usually that kind of thing alone would not be sufficient to meet the threshold for persecution, even though that's really serious and having a very serious impact on somebody's life. And in addition to establishing persecution, you also have to prove that you are being targeted because of your personal identity. So you have to show that causal connection between your persecution and your identity. So, for example, if you're being harassed by your neighbor, you have to establish that you're being harassed not because you owe them money, but because you are queer and they don't like queer people. Or if you are being denied gender affirming care at the local hospital, you have to establish that it's not because the local hospital is under-resourced, but because of targeted transphobic policies that are actually preventing you from accessing that care. It's a causal connection. Okay, next point. So in addition to establishing that well-founded fear of persecution, the second component is that you have to show that you have no access to protection from that persecution from your government. And we call this a lack of state protection that you have to establish. The logic here is that a functioning government is presumed to be capable and interested in protecting all of its citizens, unless there is clear and convincing evidence to show otherwise. And it's the asylum seeker that bears the responsibility of providing that evidence to prove otherwise. And if you are making a claim from a more quote unquote democratic country, so a country that has these traditional markers of democracy like an independent judiciary, separation of powers, free and fair elections, then an asylum seeker has to work even harder to show that all of these systems don't work and they don't have state protections. So in countries like the US and also the UK, Western Europe, Canada, there are a lot of different systems and options for challenging things and for making complaints. Whether or not you think that those are effective for you, you have to try them and you have to exhaust all your options. So for example, again, in that situation where your neighbor's harassing you, you have to go to the police, even if you believe or have experienced that the police are racist and they're not effective in protecting you. You still have to go and try. And if they don't work, if that doesn't work, then you have to go higher up to, let's say, like a police review commission. And then if you don't get a favorable decision there, continue to challenge that through the courts. And so you can see how in a democratic country, when there's a lot of different mechanisms, that burden becomes pretty hard. And then we turn to the final component of this definition, where you have to establish that there is no other location in your country where you could go to be safe. And we call this an internal flight alternative. So you have to establish that there's no other city or state anywhere in the US where you could reasonably move, rebuild your life, and live safely. And you actually have to try these options before you leave your country, or you have to explain clearly with evidence why it would be impossible or much too much hardship for you to live elsewhere in the US. This is a high threshold in general, but especially when we look at a country like the US, which is, first of all, geographically very, very large. So there's many places you could potentially move. And there's also so many different and diverse policies across different states. And federal policies may not be implemented uniformly across different states. And so the situation in the US is more nuanced, and there may be places that are safe or safer for queer and trans communities. And so that becomes also a really difficult burden to overcome. Overall, this is the definition of an asylee that you have to meet and establish. And generally speaking, because this is such a high threshold to meet, it excludes a lot of people. There are a lot of people out there who are experiencing forms of persecution or severe discrimination that are really impacting their lives, but they still may not meet that very restrictive definition under the law. And so when we apply this to the US context, given everything that I've already mentioned, asylum claims from the US are very difficult to win. And to date, we've had in Canada an extremely low rate of success for claims from the US. And that's primarily because of the issues around state protection and internal flight alternative, which often causes these claims to fail. And there are consequences for having an asylum claim refused. So in addition to, of course, lost time, because Shevin will talk about this in the next slides, but it takes a long time, you are also subject to an active removal order from Canada, and that could negatively impact your success with other immigration options in the future. However, all of that being said, we are truly living in unprecedented times, and quite frankly, the law in Canada on asylum claims from the US actually hasn't been tested when we are looking at current country conditions in the United States. So seeing the complete erasure of trans identity in the United States at a federal level, and seeing this trans erasure as a political strategy coming from the federal government, in my view, is a really significant development, because when a government themselves is the agent of persecution, or when persecutory policies are implemented throughout an entire country, state protection and internal flight alternative become less of a problem to overcome. So for example, some things that I've been discussing with some of my colleagues are the targeted denial of passports and identity documents, federal identity documents, is arguably in and of itself persecutory, particularly for folks who've transitioned physically and are now potentially stuck with identity documents with their gender assigned at birth. That could give rise to a range of real and potential fundamental rights violations. The denial of gender-affirming care at a federal level is already impacting access at a state level, and seeing, depending on how this plays out over the next several months, could give rise to a claim. And then we've also seen recently the federal government in the US signaling an intention to go after parents of trans children for child abuse and going after them criminally. And my understanding is that we've already seen this start to happen in Texas and some other states. And so all of this to say is that there are certain profiles, in my view, that could have a risk of imminent harm, and particularly for individuals who may have other intersectional risks. So also, in addition to being persecuted on your gender identity, also being vocal advocate or activist, speaking out against the government and government policies. And so potentially you're also being targeted for political opinion or maybe race grounds or other grounds. And so we can't by any means dismiss the possibility that in the coming months and years, we may in fact see cases from the US that sadly do meet the definition of an asylee. But the key takeaway here is that making an asylum claim is a high burden. It's not straightforward. It can be really complex. And it's a very uncertain option right now in terms of chances of success. But it is also a very personalized assessment, and things are evolving really, really quickly. So if you're considering making an asylum claim, talk to a lawyer. That's really my advice. Talk to a lawyer before doing anything to see if this is the right option for you.
Thanks so much. And we'll now turn it to our colleague Shevin.
Thank you, Bennett, and thank you, Swati. So my name is Shebin. My pronouns are he and him, and I'm the manager of Access to Justice and Legal Initiatives at the 590. So continuing on asylum claims, there are multiple factors impacting asylum claims here in Canada. I will speak on some of these factors, as well as benefits you can access as an asylum claimant, limitations to an asylum claim, as well as shifting perspectives on immigration here in Canada. So one of the first factors impacting an asylum claim here is wait time. So the Immigration and Refugee Board systems are designed to process 50,000 claims annually. Currently, we're seeing upwards of 250,000 pending asylum claims. And of course, as you can imagine, undoubtedly, this has significant impact on the time it takes for a claim to make its way from application through to decision. For example, outside of Quebec, we're seeing where there is an approximate 30-month wait time for a claim to be processed. So that's 2.5 years. While inside Quebec, we're seeing 45-month wait time, 3.75 years roughly. And this information was recently updated, as recent as April 30th, 2025. Of course, though those wait times are listed, we have observed as service providers that wait times can extend way beyond that, 5 years and further. So that's something that one wants to keep in mind. Now, let's talk about the benefits of making an asylum claim in Canada, or what are some of the benefits that this comes with. For one, there is legal support that an individual may be able to access. So folks may qualify to access legal aid funding to secure lawyers to help with preparing and submitting an application. And of course, representing them before the Immigration and Refugee Board. So that's one benefit of making an asylum claim. There are also multiple settlement organizations that provide support with system navigation and more holistic support. One of such organizations is the 519. There's income and social assistance, which is among benefits to be had as an asylum claimant. So claimants are typically eligible to apply for a work permit while awaiting their hearing. And typically this is for free, so there's no cost affixed to this application. An application for work permit is usually made at the point of filing an asylum claim. Claimants are also eligible to access social assistance program to meet basic needs while seeking work permits and while they're awaiting a decision. There are also some benefits rather to education. So minor children do not need a study permit to go to kindergarten, elementary, or secondary school. Asylum claimants are eligible to study in Canada while they're also awaiting their hearing. Your family members too may be eligible for study permits if they're also applying for asylum status here. There are some overall limitations to consider though, and I will be getting to those shortly. In terms of health and benefits that's associated with making an asylum claim, in Canada, the Interim Federal Health Program, or IFHP, provides limited temporary coverage of healthcare benefits to people in the following groups who are not eligible for provincial or territorial health insurance. So there are resettled refugees, asylum claimants, and in Canada protected persons. So individuals who make a claim from the US during this time frame would have access to those. Of course, not all healthcare providers are equipped to access IFHP claims, and this is one of those limitations that one wants to think through. Also, after one becomes an asylee, they may be eligible to access province or territory funded health programs. Now, I did hint at some limitations earlier, and I will be going through the same areas that I spoke on before. So, limitations surrounding education. Generally, asylum claimants are subjected to international student tuition fees while their claim is pending. However, asylees may be eligible for domestic tuition rates after a successful asylum claim. So once a decision has been given that your claim has been accepted. Now, while an asylum claimant cannot go to school while they're, or can rather go to school while they're awaiting their hearing, they would need to have an acceptance letter from a designated learning institution before applying for a study permit. Also, if at the point of applying for a refugee claim, you do have an acceptance letter from a designated learning institution, you may be able to apply at that point for a study permit. Now, some limitations are also surrounding travel. So there's restriction on freedom of movement or travel. So while an individual is awaiting their hearing, you cannot leave Canada. This means you cannot go back and forth to the US, even in emergencies, regardless of what that looks like. You cannot return to US until you have become a citizen, and that may take upwards of 8 years. It's important to know that if you were to return, you will lose underlying asylee status or protection. So the reason for your claim or your case, yes, you lose protection. So that's another thing that one wants to take into consideration. Now, once you have successfully, once your asylum claim has been successful, you may be eligible to apply for a refugee travel document. And this is somewhat like a passport, but with certain limitations, including that you cannot travel back to your home country on that travel document. Now, one would not be able to go back to their home country at all until they've become a citizen. Otherwise, you could lose your status, you could lose your protection. Now, we also recognize that there are some shifting perspective towards immigration here in Canada. And I want to talk a little bit about the 2025 to 2027 Immigration Levels Plan. So, Levels Plan, each year, the Ministry of Immigration, Refugees and Citizenship Canada tables the Immigration Levels Plan. This is a forward-looking snapshot of immigration targets for the next 3 years. Now, throughout the year, IRCC engages with a broad range of stakeholders and partners, including provinces and territories, to help inform the plan. IRCC also conducts public opinion research through surveys and focus group with newcomers, Canadians living in rural areas, Francophones living in communities outside of Quebec, as well as Indigenous people. Now, this year, the plan shows shifting perspective towards immigration. So there are plans to reduce study permits issued in 2025 to 437,000, which is a 10% reduction compared to last year. Also, for the first time, the Levels Plan has been extended to include targets for temporary residents, thus helping to reduce temporary residence volumes to 5% of Canada's overall population by the end of 2026. Now, of course, consequently, more than 40% of anticipated permanent resident admission in 2025 will be from those who are already here in Canada as permanent residents, temporary residents rather. There are a few resources that I want to share for individuals who may be considering an asylum claim. So one is the refugee determination system. I'd encourage you to review resources from the Immigration and Refugee Board of Canada. This provides hands-on information on how, from beginning to end, to navigate the refugee determination system. There's also My Refugee Claim, which is another organization or website that would be helpful, and my colleague will be sharing those in the chat. And there's Clio, Steps to Justice, which specifically points out different steps that an individual may take. And these are like hands-on or practical steps that one could take while navigating the refugee claim. Lastly, there is My Refugee Claim, which provides a list of different regional organizations that would be able to support you through making your refugee claim. Later on, I'll be speaking further to additional resources that may be helpful to you. But at this point, I'm going to return to my colleague, Bennett.
Thank you so much, Evan. So just to orient participants, we've just finished talking about all of the challenges with asylum claims, but how this moment may be shifting the landscape in new ways in terms of asylum claims for US citizens trying to come to Canada. We're now going to be talking about a different category of immigration options under the umbrella of economic pathways. And for that, my colleague Michael will be leading us through.
Thank you, Bennett. Hi, everybody. My name is Michael Hughes. I'm an associate lawyer here at Green and Spiegel, LLP, a law firm based in Toronto that practices exclusively in citizenship and immigration law. So as Bennett mentioned, I'm going to be beginning our discussion of immigration options outside of making an asylum claim. So my colleagues and I are going to be discussing temporary residence, permanent residence, and we'll touch on Canadian citizenship as well. My focus, at least to start, will be a discussion on some of the economic pathways to Canada that may be available to American citizens. And really what I'm going to focus on is temporary residence pathways, primarily work permit application categories. We'll briefly touch on study permits, permanent residence, and citizenship in a bit. So my focus is going to be on work permit applications today, primarily for two reasons. First, while it is entirely possible to apply for and enter Canada initially as a permanent resident, meaning someone who can remain in Canada permanently, essentially the US equivalent of a green card holder, most permanent residence programs, the economic ones anyways, have become extremely competitive. And the Canadian government is largely prioritizing facilitating permanent residence applications from individuals who have some sort of anchor in Canada, meaning they've already got work experience in Canada or a job offer from a Canadian employer. Second, applying for a work permit is generally a much quicker process than applying for permanent residence. And getting that work permit and starting to work in Canada will be very beneficial in the long run in terms of qualifying for and becoming more competitive as a candidate in applying for permanent residence via an economic stream. So when we talk about work permits, there are dozens of work permit application categories. We can look to free trade agreements that Canada has with other countries. We can look to categories that the government has created by or through government policy, all of which provide us with different options. Now, determining eligibility for a specific type of work permit is a very fact-specific exercise. So we need to take into consideration the applicant's nationality, age, education, work experience, language abilities, and the job that they're hoping to come to do inside of Canada. So I'll detail some examples of specific work permit application categories that may be available to American citizens. But generally, the starting point for most options is having a job offer from a business in Canada. If that's the case, you have a job offer and an employer that's willing to support a work permit application, the end result is a work permit being issued to you that allows you to work in Canada for that specific employer and in a specific occupation. That's what we refer to as a closed work permit. Open work permits are available, meaning they are not tied to a specific employer or occupation, and therefore they do not require having a job offer. However, options to apply for an open work permit are generally much more limited. So I'll go through now a few of the closed work permit options, especially ones that will be relevant to American citizens. So first, we can look at the Canada, United States, Mexico Free Trade Agreement, CUSMA as we call it in Canada. And this agreement contains certain mobility provisions that allow for American citizens to apply for specific types of work permits to work inside of Canada. So the first category under CUSMA is the professionals category. And this allows US citizens who are professionals, meaning they have, in most cases, an undergraduate degree related to a specific profession. There are enumerated professions in the agreement that qualify. So think engineers, scientists, veterinarians, nurses. There's quite a lengthy list, but if you are a US citizen, have the appropriate education and a job offer to work in that profession in Canada, we can apply for a work permit for you to do that, to work in Canada. These types of work permits can be issued for up to 3 years because it is a temporary resident document. So they are limited in duration. However, they are renewable if the employer is willing to continue to support the work permit and extend a job offer. I touched briefly on work permits in general. Often the process to apply for one is much quicker than applying for permanent residence. Permanent residence application is going to an immigration officer in an office to look at, and is therefore subject to whatever government processing times are applicable at the time. But this type of work permit for professionals can be made at the port of entry to Canada. So at the border, or at the airport on arrival, assuming there are no admissibility issues, so no criminality or security or any related issues. So there's no government processing time that you need to wait for. You're making your application, if able to, at the port of entry, and that application is being adjudicated right then and there on the spot. Second under CUSMA is the intercompany transferee category. So this might be available to someone who is working in the United States for a large multinational company that has a related company in Canada. So either a parent, subsidiary, branch, or affiliate company in Canada. If the person in the United States is currently employed by that company in the US and has worked there for at least 1 year in the last 3, they can apply to transfer to the Canadian office if they are transferring as an executive, senior manager, or specialized knowledge worker. So not just any employee of such a business would qualify, but if you're an executive, senior manager, or a specialized knowledge worker meaning you have advanced expertise and proprietary knowledge of the business's goods or services. We could look at an intercompany transferee work permit for such an applicant. Similar to the professionals category, these work permits can be issued for an initial term of 3 years. They are renewable, and they can also be made at the port of entry to Canada, assuming there are no admissibility issues. Last under CUSMA that I want to touch on is the investors category. So this category is available to American citizens who have made or who are actively making a substantial investment in Canada in a real and active commercial or entrepreneurial undertaking. So there needs to be an investment made in an active business in Canada. That business, importantly, needs to be majority owned by American citizens or Mexican citizens under this agreement. And there is no specific minimum amount that's required to be invested. It needs to be substantial. So it is a bit of a discretionary assessment that's being made by an immigration officer, but the investment does need to be proportional to the total investment that's being made in the business. Different from the other 2 work permit categories, these applications should be filed to a visa office before travel to Canada, because generally they are much larger applications and quite technical in nature. And these work permits can be issued for an initial term of 1 year, and they are extensions are possible thereafter. Moving on from the CUSMA agreement, another work permit category that might be available is called the Francophone Mobility Program. So this is a great work permit option for French speakers, people who can demonstrate that they speak or have an intermediate proficiency in the French language, American citizens included. So it's not limited to French citizens or native French speakers, as long as an intermediate proficiency in French can be demonstrated. Second, there needs to be a job offer from a Canadian business, and that job has to be located in Canada outside of the province of Quebec. Most occupations will qualify right now. And again, we can apply for a work permit for an initial term of 3 years, and they are renewable thereafter. Similar to the other work permit categories, an application can be made at the port of entry to Canada upon arrival. Important to note, to utilize this category, the language of work does not need to be French. It's just you yourself as the applicant need to demonstrate you have an intermediate proficiency in the French language. So typically what we would want to show is that you've completed some sort of education in French, or that you've passed a recognized French language test. So there are two tests that are currently recognized, the test d'évaluation de français and the test de connaissance de français. And I think we have some links here that we can provide to those two testing providers. Next work permit category that I want to speak about is called the IEC International Experience Canada program. This program allows certain young citizens of certain countries to apply for work permits. So Canada has youth mobility agreements with various countries around the world, wherein Canada says young citizens of your country who are typically between the ages of 18 and 30 or 18 and 35, depending on the agreement, can apply for a work permit to come work in Canada. And under that agreement, Canadian citizens similarly can apply for work permits to work in that country with which there's an agreement. Unfortunately, Canada does not have such an agreement with the United States. However, US citizens can still participate in this program and apply for a work permit under IEC. There's just an added first step. So in order for an American citizen to apply for a work permit under this program, they first need to be nominated by a third-party organization that is recognized by IRCC, Canadian Immigration. So Inter-Exchange, which is affiliated with Swap Working Holiday, is one such organization specifically that assists and nominates American citizens to apply for IEC work permits. Now, the reason why I wanted to touch on this work permit category specifically is because this can be a really great option for American citizens who do not have a job offer in Canada. So a job offer is not required to participate. And if you're nominated by Inter-Exchange or by a recognized organization, you can apply for your work permit to work in Canada. These applications should be made online, and the work permit that's approved, they're generally issued for up to 1 year. So shorter in duration, a second subsequent participation is possible. But again, you would need to be nominated as an American citizen by this Inter-Exchange or another recognized organization to participate. I will say Inter-Exchange has a very small quota in terms of the number of Americans that they can nominate to participate. So for reference, their quota for the year 2025 has already been met. It's been met. It was met about a month and a half ago. But we have a link to share. Inter-Exchange has a 2026 contact list sign-up sheet. So if you put your information in the sign-up sheet, the Google sheet, Inter-Exchange should contact people closer to the end of the year, probably in about November, with more information on how to apply for nomination. And for people who do receive a nomination and can apply, Inter-Exchange also provides a lot of information and guidance on the work permit application process as well. So as I mentioned in the beginning, there are a lot of various work permit application categories, all of which are very fact specific to see who might qualify for which type of work permit. Another one we wanted to mention was the charitable workers work permit category. So again, a job offer from a Canadian business is required to apply for this type of work permit. And the job in Canada must be charitable in nature, meaning that the work being done goes toward relief of poverty, advancement of education or religion, or certain other purposes that benefit the community. These applications also can be made at the port of entry by an American citizen if there are no admissibility concerns. And I'll note that simply working for a charity, having a job offer to work for a charity is not sufficient. It's the actual role itself needs to be charitable in nature. and able to apply for this type of work permit. Last thing on work permits that I want to mention is if any of these specific categories don't really fit, there's, based on your background, there's the eligibility criteria are not met, then the employer in Canada who has extended you a job offer first has to obtain authorization from the Canadian government to hire you, an American citizen or a foreign national in Canada. So this adds an initial step to the process. And before you can apply for your work permit, the employer must complete a labor market test and essentially prove to the Canadian government that A, there are no qualified Canadians available to do the job. B, the business can pay you what they say they're going to pay you. And C, that there's a legitimate and genuine need to hire you, an American citizen or a foreign national, in the role in Canada. So if all of those things can be demonstrated, the employer will be issued a labor market impact assessment, LMIA. And once that's issued, that then becomes the legal basis for your work permit application to be made. Now, the LMIA process can add quite a bit of time to the overall timing of things, depending on the actual LMIA application stream and the location of work and various other factors. An LMIA application can take anywhere from about 2 weeks to 5 months to be processed. But once it's approved, the work permit application can be made, again, at the port of entry for American citizens who are admissible, and the work permit can be issued for a duration of up to 3 years or to match whatever details were approved in the LMIA application made by the employer. Okay, so that was a bit on economic pathways. We're going to turn now to some other pathways. So I'm going to speak first quickly on study permits and Canadian citizenship, and then I'll turn over to Swati to talk about non-economic permanent residence application options. So first on study permits, if an American citizen is wanting to study, say, at the post-secondary level in Canada, so university or college, and the program of study is more than 6 months, a study permit is required. So what goes into a study permit application? Key component is being accepted to a designated learning institution, or DLI, and that institution will extend to you a letter of acceptance detailing the program that you've been accepted to, the duration of the program, so on and so forth. A new requirement, and Chevin touched on this previously, a new requirement is the school must also issue you a provincial or territorial attestation letter. What this letter does is confirm that you have been allotted a spot in the province or territory's quota annually for new international students that year. Applicants must show that they have sufficient finances to support themselves. So in a study permit application, what immigration wants to see is that you've paid your first year's tuition, and for a single applicant who's coming on their own, that they have just under $21,000 Canadian in the bank to cover costs for the first year. Importantly as well, a study plan is required for a study permit application. So I always tell clients that just because you've been accepted to a university in Canada does not necessarily mean that a study permit will be issued to you, authorizing you to travel to Canada and start those studies. At the end of the day, immigration needs to be satisfied that your study plan, so why you want to come to Canada to study in this specific program, this specific school, that it all makes sense, given your background, your previous education, your work experience, and your career trajectory. So all of that needs to be explained to an immigration officer. Once a study permit has been issued, here as an international student, again, this is a type of temporary resident. So the document is usually issued to the end date of your study program plus 90 days. And while you are here in Canada on a study permit, you are responsible for actively pursuing studies the entire time. If you are studying full-time, generally most people are able to work part-time during their studies, so up to 24 hours a week, and then work full-time during regularly scheduled breaks. So during summers and winter holidays. After graduation, depending on the program of study and if other eligibility criteria are met, students may be able to apply for a open work permit that I referred to earlier. It's called a post-graduation work permit, which essentially allows them to start working in Canada and apply the skills that they've learned in their studies to the real world and start accumulating in Canada work experience. Next, I will touch briefly on Canadian citizenship. So far we've really focused on, or I've really focused on temporary residence options. But something to keep in mind is Canadian citizenship. So if you were born in Canada, you likely qualify or are eligible for Canadian citizenship. Canadian citizenship can also be available to those who are born outside of Canada to a Canadian parent, grandparent, or great-grandparent. This was restricted actually until recently. So from 2009 onwards, eligibility for Canadian citizenship was very much restricted to if you were born outside of Canada to a Canadian parent, that's fine, you're entitled to Canadian citizenship. But if you then gave birth to your child also outside of Canada, you were not able to pass on your Canadian citizenship. A court in Canada has recently struck down that restriction as unconstitutional. So we are still waiting for Parliament to pass a new law on Canadian citizenship available to people born outside of Canada in the second generation or more. But there are actually interim measures in place right now where people who are affected by the restriction, but who should be entitled to Canadian citizenship otherwise, can actually apply to immigration right now and ask for a discretionary grant of citizenship be given to them. So something to think about if you have parents, grandparents, or even further back, anyone who was born in Canada, you might have a claim to Canadian citizenship. And I will pass back to Swati right now to talk about family sponsorship.
And Michael, just actually before we move on, we've received a lot of questions about medical inadmissibility in the context of employment-based immigration. Is there anything you'd say about that, or should we be referring people to an outside resource?
So in terms of an immigration application, medical inadmissibility can come up as a very real issue. It definitely depends on what the specific medical concern is and the severity of it. Generally, what immigration is looking at is, will your medical condition pose a danger to the Canadian public, or will your medical condition cause you to place an excessive demand on Canadian health services? If the answer is yes to either one of those things, you may be medically inadmissible to Canada. But there generally is the opportunity to respond to any concerns of immigration and try to address and alleviate any of their concerns. So, I mean, for this to come up, a medical exam would need to be completed, which generally needs to be done in the context of a permanent residence application. Anything that's temporary in nature, so a work permit application, it's not always the case that a medical exam is required. So it's something that might not come up initially anyways. If you're looking to work in the healthcare field or with children or something like that, then a medical would be required before applying for your work permit. So something to think about in that sense. But Yeah, all that to say is it could come up as an issue. Medical inadmissibility is something that immigration takes seriously, but you as the applicant do have an opportunity to respond to any concerns that immigration has and try to prove to that officer that, look, there's a plan in place to mitigate any risk that I will cause excessive burden on Canadian health services. But it definitely is a tricky topic, and I would definitely recommend speaking with an immigration lawyer on medical inadmissibility issues.
Thanks so much, Michael. And I think the comment Michael just said, I'll repeat this at the end when we're in the question portion, the questions and answer portion. What Michael just said is really relevant, unfortunately, for a lot of the questions we're receiving. We're not able to provide an individualized legal assessment for your specific circumstances, but that was helpful, Michael, to just paint the picture of the factors that are considered in the context of medical inadmissibility. So similarly, we've received a lot of questions about family relationships, and Swati is now going to speak to that.
Yeah. Thanks, Bennett. I am going to speak to that, but I thought maybe I would just address a couple of questions that I've been getting or that we're seeing on the chat before getting into it. So the first question that I'm seeing a lot is just about that 6-month time that you're allowed to stay in Canada and whether or not you could come for 6 months and then like leave for a day and then just like come back for another 6 months. The answer is technically yes, you can do that. So the second you leave the country, the clock resets and you would be able to come in for another 6 months. Typically, when you do that for like a short period of time, it's called flag polling. So there are people who will go to land borders, just cross the border and then come right back in. Now, so technically you can do that, but it does raise a red flag at the border. Why do you keep going for a short time and coming back? And like they might not let you back in, especially if you're doing that more than once. Or they might let you in for less time. So you always still have to establish that you have an intention to leave at the period of your stay and that you are coming here to visit, not to work, right? And so if you are coming for long periods of time and you're doing it 6 months, 6 months, 6 months with like a little one day in between, that's definitely going to raise red flags. But you can technically do that, come in for 6 months, leave for a couple of weeks, leave for a couple months, come back. That's all possible. The other question that we're seeing was relating to asylum claims and whether or not, you know, sort of like what happens in the context of a family asylum claim. So what if it is the child that's being persecuted on the basis of their trans identity or whatever it might be? What happens with the parents? So if somebody's making an asylum claim, if you're making it as a family, so let's say the child is claiming, but the parents are also included on that asylum application, every single person has to establish their claim separately. So every claim is assessed on an individual basis. So usually families are put together when they claim asylum, but the claims are still assessed individually. So it's very possible, and I've seen it happen many times, where there's a family and one member of the family is granted asylum and other family members are rejected because they couldn't individually establish that they would personally experience persecution. So what happens in a situation of a minor child is a little bit more complicated because if you're claiming with your spouse or your children and you are the successful claimant, you can include those family members on your application for permanent residence once your claim for asylum is accepted. If you are a minor child who's accepted and your parents are rejected, technically you cannot include them on that first application for permanent residence, but as dependent family members because parents don't qualify under that category in a permanent residence application under the asylum class. But if a young trans person claimed asylum and then they were successful and they applied for PR and they got their permanent residence, then they could apply to sponsor their parents as permanent residents as well. I can also see situations, which I'll talk about in a bit, where, you know, if you were parents to a minor child who's alone in Canada and who's an accepted claimant, I think you could likely argue for a temporary resident permit or another kind of permit to be able to be reunited with your child in Canada and potentially even request a special exemption to be included on their permanent residence application. So the thing to know about a lot of these immigration applications is like you can sometimes ask for exemptions to existing requirements and also just kind of put forward very specific circumstances and make requests. based on maybe, new circumstances that wouldn't have normally have been contemplated. So the final thing I wanted to just briefly touch on was this issue around criminality, and a couple of people noting that, they're afraid of being criminalized by the US government, whether it's for, having a trans child and being criminalized for child abuse, or for other potentially politically motivated criminal charges. So the one thing that I'll say is that in terms of criminality in Canada, the way it works is that if you are convicted of a crime in whatever country that you're from, we have to have an equivalent crime here in Canada in order for you to be criminally inadmissible. So an example that I'll give is that in Uganda, it's illegal to be gay, right? And you can't get married. And if you do, you can have a conviction under a sodomy law. That is not a criminal conviction. That is not a criminal offense in Canada. So that does not trigger criminal inadmissibility provisions. It might raise a flag, and so somebody, would have to explain and disclose that they've been charged, but then explain why it's not a criminal offense in Canada. And so that's something that could potentially also be relevant in these cases. So of being charged with proxy offenses based on an actually politically or identity-based criminal charge. So in short, if you are charged with a criminal offense in the US, you do have to disclose that prior to coming to Canada. But I highly recommend getting like a letter from a lawyer, a criminal lawyer in the US if you are coming to the border, so that you're able to sort of explain the circumstances around the offense and explain why it shouldn't bar your entry into Canada. So all to say, if you're facing that issue, it could cause some issues at the border. And so definitely worth having a discussion with immigration or a criminal lawyer about that. But I think there's definitely things that could be argued, and that we're seeing it now, even for people who are being targeted for political opinion, who are, facing some issues at the border, but can potentially overcome that. Okay, so I'm just going to turn to another important pathway here, which is our family status sponsorships or family reunification pathways. So a Canadian citizen or a permanent resident over the age of 18 has the right to sponsor their close family members to Canada. And that application can be done from within Canada, where everybody's inside Canada, or where people are outside of Canada. Now, unfortunately, eligible family relationships under this family class category are quite limited. So a Canadian citizen or permanent resident can sponsor their spouse, common law, or conjugal partner, as well as dependent children of their spouse or partner. They can sponsor a dependent child, so somebody who's under the age of 18 and doesn't have their own legal partner. And they can technically also sponsor parent or grandparent to come to Canada. Now, I just want to put a little caveat on the parent or grandparent class, because in practice, this is a really ineffective mechanism that exists. There is a lottery every year for selecting who gets to apply, a random lottery for who gets to apply for a parental sponsorship. It is capped every year at a high number, and that cap is usually reached very quickly. It's a very, very, very long backlog. I read recently that right now they're looking at people who applied in 2020. And so we're looking at like 5 to 10 years potentially. And so long wait time. So it's not a very attractive option. And I definitely think it's important to see if there's other options available to you. But that is there. So it's something to still be aware of. So what this means is that there are, of course, a lot of other family relationships that are not eligible through a sponsorship application. So you can't be sponsored by a sibling or a cousin or an aunt or an uncle or chosen family, subject to some very, very limited exceptions. But generally speaking, it's really your spouse, your child, and potentially your parent. And when we look at spousal sponsorship specifically, what you have to establish is that it is a genuine or bona fide relationship that is not for the purposes of immigration. You can just click to that next point, Bennett. So y'all would have definitely heard about green card marriages. So we definitely have that here too, right? Folks who are marrying individuals for the purposes of being able to immigrate. And so immigration officers are very much on high alert for this kind of thing, and they are really looking with a lot of scrutiny at spousal sponsorship applications to see like, okay, is this a genuine relationship? What kind of evidence do you have to show that? Can you prove that you've been together for a long enough period of time? Do you have text messages? Can your friends and family attest to this? Do you have joint bank accounts? All of this kind of thing they're really going to look at, potentially give you an interview if they have more suspicions. So you really need to ensure that you are in a genuine relationship and that you are able to prove that with evidence. But the good thing about spousal sponsorships and for also dependent children, if that option is available for you and you are in a genuine relationship with a Canadian citizen or PR, permanent resident, is that once you establish that, it's a really straightforward application. It's very non-discretionary. So if you have that true family relationship, then that Canadian citizen or PR has the right to sponsor their family through our family reunification pathways. And so the process itself becomes relatively straightforward. And if you are applying for a spousal sponsorship from within Canada, like your spouse and you are in Canada, then that spouse, potentially the sponsored spouse, potentially has the option to apply for an open work permit while the inland application is being processed. And so that's really a major advantage for a lot of individuals. There are some income requirements for sponsorships. Primarily, these apply to parental and grandparent sponsorships, where you really have to show that you have a certain amount of family income. But for spouses and for dependent children, very, very basic. The sponsor just cannot be on social assistance. But other than that, you don't have to show that you make a ton of money to be able to sponsor your spouse or dependent child. And the process, again, as I mentioned, is relatively streamlined depending on the relationship and the country of origin. It could take anywhere from a year to 2 years to actually complete that sponsorship process. Okay. And then we'll move to the next slide. So there's just a couple more applications I'm going to mention. So the first is a humanitarian and compassionate application. So this is an application for permanent residence that is done from within Canada. So ordinarily, when you apply for PR, you have to apply from outside of Canada. But this application is effectively asking for a special exemption from that requirement to allow you to apply for a permanent residence on humanitarian and compassionate grounds from within Canada. An agency application is much more holistic and broad and less of a high threshold than a refugee claim. You don't have to establish that you are facing an imminent risk to your life or that you're facing persecution. And the main factors for consideration are a bit broader. So the first thing that they'll look at is your establishment in Canada. How long have you been in Canada? Are you involved in the community? Do you have ties to Canada? Do you have family members in Canada such that you're integrated here and removing you from the country and asking you to apply from abroad would cause you significant hardship? A second thing that they look at is the best interests of any children involved in an application. So if there is a child that's impacted in any way in this application, then those factors can be considered. So what would happen to the child? What would be the impact on the child if they were forced to leave Canada, or if their parent wasn't granted PR, or if they had to live in their country of citizenship? And then the final thing that they look at is this broad category of hardship in your country of origin. So this is where, again, they're looking at things a bit more broadly. Things like discrimination or economic factors are all admissible on this kind of application. And it's again, a holistic sort of broad analysis about the overall impact and how much hardship it would cause you. So this is an option for people, again, from within Canada, but I want to note that it is highly discretionary, extremely discretionary. It's kind of evaluated on a case-by-case basis, and there might be one officer who looks at an application and says, oh yeah, I think this meets the test, and then another officer who looks at it and says, no, I don't really think so. So a lot of discretion there. While an application is being processed, you don't have immigration status in Canada, so you are at risk of removal, and this is definitely something to be aware of. It also takes a long time, like multi-years. And again, you're often in a situation where you don't have status during that time unless you try to get some temporary status in the interim. And so it's really the best kind of application for people who've already been in Canada for a long period of time, like I would say minimum 6 months, but like really you want to look at like a year, and who don't have other options, who are really here, they don't have other pathways, and this is the pathway, and they're established, and they have other factors that can be considered around hardship. So that's really when I would recommend potentially exploring this option. And then the final thing that I wanted to just very briefly mention is something called a temporary resident permit. So a TRP is, again, as by the name suggests, it's a temporary permit that allows foreign nationals who are otherwise inadmissible to Canada to enter or remain in the country for a temporary period of time, sometimes with work authorization. Sometimes you can also get health authorization on these TRPs. TRPs are issued under very, very exceptional circumstances and are usually valid for, 6 to 12 months, but honestly can be less. I've seen TRPs issued for like a week. Things that are considered are family reunification, medical emergencies, business or work-related reasons for why you have to be here temporarily, and humanitarian considerations. And again, this is super exceptional, also highly discretionary, but the reason I mention it is because I can see how potentially a TRP could be supportive in certain situations. Like, for example, a parent who has to come to Canada to get gender-affirming care for their kid. They're saying, okay, I'm going to be here for 6 months, and I need to work while I'm here to be able to support myself, to support my child. Please grant me this TRP for this like very distinct or small period of time. Or in a situation like we were talking about with an asylum claim, and your kid's granted asylum, your claim is rejected, I can certainly see a strong argument for a TRP to be issued in that case to allow you to remain in Canada while you are, trying to figure out your options and taking care of your child. So it is something that's available, but again, it's untested, and it's not super clear, and it could take some time. So just for you to be aware of that.
Excuse me, I just pressed the wrong button. Thanks so much, Swati. We're just going to be moving now towards resources for next steps. So I also just want to acknowledge that I know there are dozens of questions that are unanswered. In a lot of cases, it's because the questions raise specific circumstances that we aren't able to get into related to an individual's particular circumstances. But we'll now be talking about some resources to find out more information. And the other point, I'll make this point again at the end, we're recording today's conversation. It will be posted as well as, along with resources, the ones that we've listed and additional ones that we'll identify based on some of the questions we've gotten today. Shevin, I'll turn to you for a moment.
Great. Thank you, Bennett. So we would have, like Bennett mentioned earlier, shared some resources with you, some of which I'll be repeating, and there are some additional resources here. And these are dependent on different pathways that individuals are looking to migrate to Canada. Specifically, I'd say for general information about immigration options, I'd recommend Immigration, Refugee, and Citizenship Canada. There's all the information that you need there in terms of pathways. You may be able to get more detailed information on specific websites and pathways, and I'll speak on some of those. For one, if you're seeking to access legal representation, which may be in various aspects or different parts of the country, then I'd recommend that you check with Canadian Bar Association. So you may be able to find different resources that would be helpful or applicable to you there. For learning more about immigration options available to you, also you could check out Steps to Justice. They have a website that posts detailed information on immigration options, immigration law. There's a Safe Third Country agreement, which was mentioned earlier, and I know that there may have been questions about whether it's applicable to you or not. That is also another website I would encourage you strongly to check out. We spoke about work permit, express entry, sponsorship application, and HNC application. These are also resources that would be available to you, and my colleague will go ahead and share those in the chat. Of course, feel free to ask any questions that you may have. We'd be more than happy to respond to those. And if there are additional resources that we think may be useful or helpful to you, then we'll share that with you too. All right, thank you so much. And Bennett, I'm passing it back to you.
Thanks, Kevin. So we also just wanted to lift up some of the organizations doing supportive work in the United States right now, recognizing that based on the information we're sharing, it may not be obvious if coming to Canada is in fact an option for you. So here are 3 organizations that are providing on-the-ground support within the US, especially helping folks who are in more vulnerable states move to more protective states. So I now turn to questions, and I know there have been a lot. As I've said, unfortunately, we can't cover every specific question that has been raised. The purpose of today was really to just help you triage the various information and have a better sense of what might be available to you to explore more. But I think that for lots of people, that's going to require having future conversations with a lawyer, providing advice on your personal circumstance. I know we received a question about the about express entry, and Michael's going to say a word or two about that now.
Yeah, thanks, Bennett. I can touch on that briefly. So I mentioned that it is possible to apply to Canada to enter initially as a permanent resident. So you're not entering as a foreign worker or a tourist. You're entering Canada as a permanent resident. The main federal economic program is express entry. There are multiple application streams within that umbrella of express entry, and very high level. Individuals may qualify based on their foreign work experience or work experience inside of Canada. If you're eligible under one of the main programs, you are assigned a score based on all of your background factors. So your age, education, work experience, language abilities, all of these various things. A score is assigned to you, and you're placed in a pool of everyone else who's interested in applying for permanent residence via express entry. Every couple of weeks or so, the Canadian government will invite the top ranking candidates to actually apply for permanent residence based on their score. And that application essentially becomes a question of proving that everything that you've said when making your profile is accurate, and that the score that you've received is accurate. I didn't get into it too much in this presentation because, as I mentioned before, it has become extremely competitive to qualify for permanent residence under express entry and to actually receive that invitation to apply for PR. So what I mean by that is that the minimum cutoff score that has been required to receive that invitation has been quite high for the last couple of years, because there are so many people, so many candidates in the pool who have expressed interest. So not to say that it's not possible, but generally what we're seeing is candidates who are more competitive are those who are already inside of Canada with a work permit and who have obtained at least 1 year of Canadian work experience. And then the younger you are, the more highly educated you are, those are other factors that will work in your favor in terms of increasing your score. So all that to say is that was the reason for the presentation being geared towards temporary residence first, work permit options, and those work permits being beneficial long-term in the context of a permanent residence application via express entry or another economic stream.
Great. Swati, were you going to address any question in particular? Not trying to put you on the spot. I just saw your face come up. Otherwise, I'm just going to, okay, great. And if others have caught a question that they'd like to address, feel free to unmute yourself and speak, because I'm just triaging a little bit. The one thing that I'll say again, based on questions that are coming up, is just a reminder that we're recording this session and the links will be available. So all the links that we've shared during the chat, as well as links for resources that were embedded within the PowerPoint presentation. And we'll be sending the link to the video as well as the link to resources to all registrants for this session, including people who weren't able to attend. In terms of oh, one question actually that I'll invite all panelists to speak to just in the remaining moments. We've received the question of consequences of applying under one stream for your chance of success under other streams. So for example, applying during under express entry and also applying under an employment category, or applying under a family relationship category and also applying under an employment category. Does anyone have any comments on that? I know we've addressed the potential consequences of an unsuccessful asylum claim.
I can speak to that first. I don't think that there's necessarily any harm in pursuing multiple application categories. As Bennett, you just mentioned, I think the most detrimental consequence would be filing an asylum claim, and then the consequences of that on especially a temporary residence application in the future, so a work permit application in the future. There would be definitely negative consequences there. But in terms of applying for permanent residence, say via family class or an economic class, I don't think that there's necessarily any harm in doing that. The way I would approach it is looking at all options that might be available and then pursuing whatever is the most feasible, or whichever would have the strongest application, and considering things like processing times for the specific application as well. And pursuing one, not necessarily all of them that are available.
Thanks so much. We've also received a lot of questions about accompanying family members. So if anyone has anything based on the not in terms of sponsorship for permanent residency applications, but for example, asylum claims or for work permits, all those different categories. If anyone has anything to add about that, please feel free to do so now. I know we're almost out of time, so we can also provide links to information about that in the posted version of this information. Okay, so this is my final opportunity to panelists if they have anything to say. I just noticed a couple unmute, so I'll let Swati speak and then Michael.
Michael, you want to go first? Speak to that last question.
Sure, I'll just speak briefly to work permit or study permit applications. So if you are the principal applicant applying for a work permit in Canada or a study permit, your spouse may be able to accompany on an open spousal work permit. Eligibility criteria for those work permit categories has recently changed and been quite restricted. So eligibility for an open spousal work permit largely comes down to what your spouse, who the principal applicant is, what job they are doing in Canada, specifically if it's a highly skilled job, so at the professional or managerial level, or in a specific other occupation that immigration will allow, and that your work permit as the principal applicant has been issued for at least 16 months in duration. Then your spouse may qualify for an open spousal work permit.
Great, and Swati, you're just muted if you have.
Yeah, I just want to very briefly touch on this like citizenship by descent thing, because I saw a few questions. So yeah, you know, like it's very broadly speaking, and again, this isn't my specific practice area, but what I understand of how things are operating right now with these recent changes, it is not actually just limited to great grandparents. It is removing the first generation limit altogether. So technically, if you can prove that you have a Canadian ancestor, then you may be eligible for Canadian citizenship. And what my understanding is, you just have to be able to have the birth records to really establish that, right? So that could be really challenging beyond your great-great-grandfather or grandparent, right? But that is, if you are able to show that you have a Canadian ancestor and you can track that through the generations, then you may indeed be eligible for Canadian citizenship. And I just want to pop this other link in. Maybe you could pop this in, Bennett or AJ, but I've been talking to some colleagues and they have done some of these citizenship applications for LGBT citizens. And there is actually a provision to apply urgently for Canadian citizenship certificates, specifically to avoid situations of potential harm or hardship due to factors including sexual orientation or gender identity and expression. So for individuals who have potentially a right to Canadian citizenship and are also facing hardship that they can establish based on their SOGI-esque identity, then they could potentially have this application processed quite quickly.
Okay, thank you, everyone. We're now over time. We really appreciate the presence of so many of you today. I'm so grateful to the panelists for offering their expertise. And we will continue to look at all of the questions we've gotten and think about what additional information we can help provide to participants and those interested in these critical topics at this time. So a final reminder that unfortunately the nonprofits that participated in today's call are not able to provide individualized legal assistance to U.S. citizens at this time. The contact information for Green and Spiegel, our private law firm partner in this session, is posted on this final slide, and they're able to provide consultations in some cases as well. So you're welcome to contact Green and Spiegel along with the other resources that we've posted. So thank you so much for your presence today, and we wish you all the best.